Good evening, everyone. Today we're going to be talking about Chapter 2, which is the sources of criminal procedure. And once again, just to reiterate, we're learning, or I'm going to be actually giving this lecture, of course, from our textbook, Criminal Procedure by Matthew Littman. I'm actually using the first edition, but of course there's the second and the third edition. They're the good books, but I use this edition because I just like the skeletal structure. It's a little easier for me to um, give my what do you call it? Actually, give my lecture. So let's go ahead and get started. As a basic introduction to the sources of criminal procedure, and that's what we're essentially going to be talking about tonight, where criminal procedure law comes from. So there are a myriad of places or sources of criminal procedural law. The law of criminal procedure provides a roadmap that guides police in the detection, investigation of crime, and the detention of suspects, and provides directions to defense attorneys, prosecutors, and judges in the prosecution and punishment of offenders and in the appeal of verdicts. So that paragraph of that sentence said a whole lot, and we're going to talk about that. The U.S. Constitution is the primary source of the law of criminal procedures. We said before, the Constitution is actually legislative made law. If you think about it, a group of the founders actually created the Constitution, and they were essentially legislatures. They were representing the states at the time, 13 colonies, but they created a Constitution. So that is the supreme law of the land. So that's where a lot of our criminal procedural law comes from. Um, so the Constitution establishes the powers of three branches of federal government, allocates responsibilities between the states and the federal government, and sets forth the fundamental rights and liberties of individuals. So the Constitution is difficult to amend, and as a result, it would be extraordinarily difficult for a government to change the rules of the game and alter the system of government. So that's one of the good safeguards of our government. The founding fathers thought enough to make the Constitution a living, breathing document, and it still lives today. So it's a living, breathing document. So it can always be adjusted, but there is very hard to adjust it. So they almost made in creating that Constitution and giving us a means of adjusting it if it needs to be adjusted. We've almost made our government kind of what would I say, overthrow proof. So in having a constitution rather than overthrowing the government or staging a coup of sorts, we can just go to the amendments if the people feel like something needs to be changed. So that's the cornerstone of our democracy, the Constitution. Um, the last half of the 20th century has witnessed the nationalization or constitutionalization of the law of criminal procedure. The U.S. Supreme Court has held that most of the provisions of the Bill of Rights of the U.S. Constitution are incorporated into the 14th Amendment and applicable to the states through that 14th Amendment. So we're going to talk about a little bit about the history, how the Constitution at first was just federal, and then through case law, and then through constitutional amendments, um, we the Supreme Court kind of changed and said, the Constitution of the United States is also going to apply to the actions of state law enforcement. So as a result, individuals generally enjoy the same rights in the federal criminal justice system and in the criminal justice systems of the 50 states. So, sources of criminal procedure. There are several significant sources of the law of criminal procedure. These include the U.S. Constitution, as we said before, the U.S. Supreme Court, state constitutions and courts, federal and state statutes, rules of criminal procedure, and the American Institute's Model Code of Pre-Arraignment Procedure, and the judicial decisions of federal and state courts. So we're going to kind of touch on all those. I know that was a lot. So let's start off with the main one. As you said before, the U.S. Constitution. The original Constitution of 1788 includes four provisions that address criminal procedure. The first 10 amendments, comprising of the Bill of Rights, were added to the Constitution in 1791. The first eight amendments to the Constitution include 15 provisions addressing criminal procedure directly. The U.S. Supreme Court as a second source. In 1803, in a very important case, Marbury v. Madison, the U.S. Supreme Court asserted the authority of judicial review, and that's the right to define the meaning of the Constitution and the right to hold unconstitutional federal and state and local laws that do not conform to the requirements of the Constitution. So Marbury versus Madison was a very important case because it essentially gave the courts of the United States, specifically the Supreme Court, the right to interpret law. So it gave them the right to now hold things unconstitutional, and it gave them the right to review things. So we call it that was the case that created judicial review. The Supreme Court is the chief interpreter of the meaning of the Constitution, and the court's judgments bind all other courts. The president, Congress, and state officials are also bound as well, and every individual in the criminal justice system. So when the Supreme Court says something and it is something that affects criminal procedure, at that point, now that means it's law for everyone. So it doesn't mean that the states can't do things to make that law stronger, but they definitely can't do things to make whatever law comes from the Supreme Court weaker. So we talked about the U.S. Constitution, the U.S. Supreme Court. Now we're going to talk about state constitutions. The 50 state constitutions include a Declaration of Rights. The interpretation of state constitutions is a matter of state courts. Very seldom do state court constitutions kind of go into the federal side. It had to be something that's trying to abridge some type of federal law or federal constitutional right. The rule is that a state may not provide a defendant with less protection than the corresponding federal provision. A state, however, may provide a defendant with more protection. That means they may strengthen whatever the constitutional right is, but they cannot weaken it. So they cannot abridge the U.S. Constitution in any way. Federal and state statutes. So statutory laws, we say, is what we call is legislatively created law, where the legislature, there'll be a bill on the floor. They will have to pass in the federal side, it has to pass the Senate and the House and the Senate for it to be law. Same thing happens in the states. Of course, states don't always have a House and the Senate, but there's always a state legislature, and they determine what's going to be the law in whatever individual state they're in. State legislatures and the U.S. Congress have passed laws addressing criminal procedure. Statutes can be very important for defining a defendant's rights in the criminal justice system. The federal statutes, for instance, include provisions on the requirements of speedy trial, witness protection, and post-conviction DNA testing. So we talked about three major sources of criminal procedure. We talked about the Constitution, the judiciary, and their decision making and their interpretation, and we talked about statutory things. So now we'll move on to the rules of criminal procedure. Sometimes different statutes or the states and federal government can actually adopt what we call rules of criminal procedure, like a book just on criminal procedure. Like, this is the criminal procedure in this jurisdiction. The federal rules of criminal procedure detail the steps that are to be followed in the criminal justice process in the federal system, from the filing of a complaint through a verdict and sentencing in district court. State courts generally have comprehensive rules of procedure that follow the example of the federal rules. Roughly 1/3 of the state constitutions provide that the rules of procedure drawn up by judges are more important than or take precedence over the laws passed by state legislature. So, of course, in most states, they want the judges to be interpreting law. Because as you'll learn, a lot of times statutory law can sometimes be ambiguous and unclear, and that always leads to someone, now once they go through the court system, they may get convicted, and they appeal based upon the ambiguity or the unclearness of that law as it's written. So at that point, it's now the court's job to interpret what that's going to mean, and they essentially give the system a binding decision or a binding rule. So that's the importance of judicial review. That's what judicial review does. Then you have model code of pretrial procedure, and I think I said this last lecture. Model codes are comprised of, I guess, the opinions, um, and I guess the input of, you have academia, so you have people that teach law and the experts. You have judges who may be on these panels or may be a part of or give some input. You have practitioners of law, attorneys, and even prosecutors and people in different positions to say, hey, let's get together and try to figure out what we can, what body of law, what we can kind of give to the system as an advisory opinion, or to give advice on what the system should do. And these are things that we all agree to when it comes to procedure. But like I said, they're just models, so that doesn't mean they necessarily have to be adopted. And model penal codes are not law. They're just advisory opinions or books of advisory opinions on what the court should do. Now, some jurisdictions actually adopt the model penal code, or the well, in this case, the model code of pretrial procedure, but it doesn't mean they have to. So it's not really law unless it's adopted. The American Law Institute's non-binding, as I said before, model code of prearrangement procedure, which is created in 1975, or the first edition, addresses pretrial investigations and has been cited by judges and declaring criminal procedure issues. So sometimes judges can use that as advisory when they're trying to make a decision. Like, what does the model code say? Let's read into it. And they use that in their decision making process. The development of due process. Due process is very important. Anytime you hear us mention due process, we're essentially talking about the fairness of trial. So in other words, we're giving someone a fair opportunity to represent and defend themselves. The last half of the 20th century witnessed the nationalization, or what legal scholars refer to as the constitutionalization of criminal procedure. This involves interpreting the 14th Amendment due process clause to extend most of the protections of the Bill of Rights to the state. So anytime we talk about incorporation, that means essentially the 14th Amendment the 14th Amendment incorporates federal law and says that, these federal protections are also going to apply to the states. Okay, the 14th Amendment, very important amendment. So that was a very important decision. So that decision in and of itself created like I guess a two-tier system where either you're getting charged in federal court, or you have federal law enforcement that's chasing you and charging you, or you have state or local law enforcement. But the Federal Bill of Rights, or the Constitutional Bill of Rights on the federal side, only applied to what federal law enforcement did. So one thing you learn, and I am a defense attorney, and so sometimes there is a little bit of bias in the way I teach, but I have friends in law enforcement, and I do believe law enforcement is needed. But what I will say is law enforcement and the detection of crime is a cat and mouse game. What happens is sometimes the cops have to almost become bad guys to catch bad guys. That means they essentially cheat, and you always hear me use the word circumvention. That means to go around. So what happens a lot of times, if you have rules on the books, and law enforcement is always going to create a way to go around that rule, because of course when you have constitutional rules that protect us as individuals, it always hampers. Most of the time, it's very seldom do you find a rule that both protects individual rights and helps law enforcement in their detection of crime. There's usually there are two things that are opposing, and that's why like I talked about in the first chapter, it's always a balancing test. So if one is heavier, the other one is lighter, and vice versa. So those two things always work against each other. So the best thing to do is to find that perfect balance. But um, I said that to say that, and the reason I'm saying that is you're always going to find situations where there's some type of circumvention. So, of course, in 1833, if a court says that federal law or federal law enforcement is bonded by by the federal constitution, but the federal constitution does not bind state and local law enforcement. What do you think law enforcement is going to do? They're then going to start these investigations, and they're going to say, and because they're kind of handcuffed by the Constitution and the Bill of Rights. What do you think they did? They say, "Oh, we'll let the local authorities make the arrest and do the investigation because they don't have the same hindrances." So that's the way you kind of circumvent. Criminal justice was viewed as a local matter. This system of states' rights ultimately did not survive the Civil War. In 1868, Congress passed the 14th Amendment. In 1873, in the slaughterhouse cases, the Supreme Court rejected the argument that the Privileges and Immunities Clause of the 14th Amendment extended the Bill of Rights to citizens of the states. Individuals now look to the Due Process Clause of the Fourth Amendment to secure their rights against state governments. The Supreme Court has adopted three approaches to determining the protections extended by the 14th Amendment to the state governments. You have fundamental fairness, you have total incorporation, then you have selective incorporation. So let's talk about the due process clause. What does that mean? Judges favoring a total incorporation approach argue that the rights that are considered fundamental to the American democracy are set forth in the Bill of Rights and accordingly are incorporated into the due process clause of the 14th Amendment. In other words, that means it's total incorporation. So that means they all apply. So this law goes at, essentially now applies to all the states. There's no abridgment of, no picking some and not picking others. It all comes in total incorporation. The fundamental fairness approach leaves the states free to conduct criminal trials so long as the procedures are consistent with with fundamental fairness. So it's a little bit ambiguous, right? Words like fundamental fairness, there's not really a definition for what fundamental fairness is. Then you have the selective incorporation approach, and it argues that the provisions of the Bill of Rights that are fundamental to liberty are incorporated into the Due Process Clause. Then you have the selective incorporation plus, that's another approach, argues that the fundamental rights and the Bill of Rights, along with other fundamental rights outside the Bill of Rights, are incorporated into the Bill of Rights. So you see with selective incorporation, you kind of pick, it's all about only the important ones, but not all of them. So those are kind of the three, or actually three plus one approaches to the due process clause. Now let's talk about fundamental fairness by itself. The Supreme Court developed due process fundamental fairness tests in a series of cases between 1884 and 1908. Lawyers and their clients, however, were continually disappointed over the Supreme Court's refusal to recognize that rights protected by the Bill of Rights are protected by the 14th Amendment. In 1932, in Powell v. Alabama, the Supreme Court recognized that the right to a lawyer in a criminal case is fundamental and is protected by the Due Process Clause of the 14th Amendment. This was followed in 1936 in Brown v. Mississippi, in which the Supreme Court held that confessions had been extracted from three African American defendants through physical torture, and that the use of confessions, thus obtained as basis for conviction and sentence, was clear denial of due process. So we have total incorporation. Uh, Justice Hugo Black was the Supreme Court's foremost proponent of total incorporation. In 1947, Justice Black fully articulated his theory in his dissenting opinion in Adamson v. California. This theory was never attracted a majority of judges. Judge William O. Douglas articulated the total incorporation plus theory. So we don't talk about total incorporation as much. We normally talk about fundamental fairness. Selective incorporation. In the 1960s, a majority of the judges, rather than embracing total incorporation, endorsed a selective incorporation approach, first articulated by Justice William Brennan. This theory is based on the view that the Due Process Clause incorporates the entire provision of various amendments that comprise the Bill of Rights and applies to the states to the same extent as to the federal government. They call it jot for jot and case for case. The court also has failed to incorporate five provisions of the Bill of Rights into the 14th Amendment. As a state is free to pass a law to include provisions in its constitution that extends the protection to these five provisions to the citizens. So, like in North Carolina, most of these Bill of Rights we also have those in our state constitution. So whatever with selective incorporation, it almost allows the states to figure out what parts of the Bill of Rights they're also going to include in their state constitution. So sometimes the state ends up protecting just like the federal constitution, just because they've now adopted or written in their own constitution the same thing. So equal protection. The 14th Amendment guarantees individuals equal protection of the law, in addition to providing that no state shall deprive any person of liberty or property without due process of law. In 1954, the Supreme Court declared in Bowling v. Sharp that the Fifth Amendment due process clause imposes an identical obligation on the federal government to ensure the equal protection of the law. The sense that we are being treated equally is essential to our respect for the law. One area where equal protection claims arise is a prosecutor's decision to charge and prosecute an individual with a criminal offense. A claim of discriminatory or selective prosecution and request that that a court dismiss a prosecution must overcome the presumption of regularity. What that means is uh, the actions of a prosecutor are always presumed fair. That doesn't mean they can't be rebutted. So it's like a rebuttable presumption. So that means the actions of a prosecutor are always presumed on their face and at the time they're done to be fair on their face. Um, a claim of discriminatory selective prosecution. Let me see. Let me. I missed. Okay. So it must overcome a presumption of regularity by presenting a clear and convincing evidence of discriminatory impact and intent. So there's two different things. This is the hard thing about actually proving discrimination in America with anything, whether it's the actions of a prosecutor or the acts of federal agency or anything. um, that's the one thing about the equal protection clause. It's not just that you prove impact. So impact is when we talk about the numbers. So when we look at a system, we look at the system and we can look at numbers and say, hey, this prosecutor's office seems to be prosecuting black people more than they're prosecuting white people, or they're prosecuting minorities way more than they're prosecuting um, the majority of people or white people. So of course, a lot of there are always numbers that say that, right? So most people think the numbers by itself, well, that means it's discrimination. But according to the equal protection analysis, or the definition that we're given, is not just about proving that the numbers don't lie. That, hey, that it's obvious by the numbers that there's discrimination. Also must show intent. uh Intent is very hard to prove. It's like if someone's not doing the wrong thing, you almost have to pair bad numbers with bad conduct. And most people that are racist and are doing, or they're at least biased, never actually say anything to show they're biased. So you're never going to prove that someone is racist in the way they prosecute, unless you have to almost catch them on tape saying the N word while they're prosecuting to show that there may be a bias. So, but who really does that these days? So it's very, very hard to prove bias in certain situations. And that's why. So it's not just about proving the impact or the numbers that don't lie. You also have to prove that there's some intent. And of course, I'm going to jump to criminal law, but there are two parts of every crime, right? There's an act and a mental state that has to be paired with that act. So there's an act that's committed, and that act has to be paired simultaneously with a criminal intent. What this equal protection section is essentially saying is that we can't just show that there's discrimination by the act or by the fact uh, that the numbers don't lie, and there's obviously some type of bias because there are more black people being prosecuted. But we also have to show that there's some type of intent, and intent is super hard to prove, and like I said, unless the person is prosecuting cases and they're almost saying, "Yes, I'm a racist," or "I hate black people," or they're using the N word or something. But no one does that, so it's super hard to prove discriminatory intent. So that's why a lot of discrimination claims, especially with prosecutorial misconduct, a lot of them go kind of what do I say, uncorroborated, because that last thing is very hard to prove. So you can always prove what the numbers say. Um, The impact of Supreme Court decisions. Supreme Court decisions establish a new rule. What we mean by that is it says this is what the new rule is. So we have precedent, right? But precedent can be changed, but precedent can only be challenged when that old rule is challenged. Essentially, what we're saying is that that old rule is sometimes outdated. That's the beautiful thing about the Constitution and the way our constitutional democracy is set up with the three branches of government. It allows for the document, the Constitution, which is words on a piece of paper, it essentially lives and keeps living because it's always subject to change. You got to think at the time they created the Constitution, they didn't have cars and they didn't have technology. So they wrote the First Amendment. They just talk about freedom of speech. So what do you think they were talking about? Printed media. Uh, so there was a difference between what the media was then and what it is now. Now most people read the newspaper online. So you have all this technology. So there's now a difference in printed media and now what you see online. So the First Amendment has now been stretched to include more because the Constitution is a living, breathing document. So that was important. So that's the important part of the Constitution. And by creating judicial review, you give the court system the ability to now interpret and change the law. So sometimes laws become outdated, and they can only be and they're changed because now we have judicial review, and that allows the courts to adjust the law and create new rules um, that are more applicable to modern times. So the Supreme Court decisions establishing a new rule are retroactive and are binding precedent on all future cases. So that means they're retroactive and they're of course binding on all future cases. So that means that there's some type of constitutional change that makes a law less punishable. That means everyone that was punished before can now seek relief. So if possession of marijuana is a felony, no matter what it is, and they change, and of course the Constitution says that law is the court says that law is unconstitutional. That now creates a new rule. So that means it's going to be applicable retroactively, meaning that now since that rule is changed and now that it's no longer a felony and now can only be punished as a misdemeanor, that means now you can go back. Those people that have felonies can now seek relief and say, "Well, I want my misdemeanor now. Please reduce my, change my record." And it also the new rules also applied for to every case for moving forward, so in the future. So so it is retroactive and it's binding precedent on all future cases. And all future cases currently at trial, and cases on appeal. So that's what new rules essentially mean. That's the impact of a Supreme Court decision. Judgments establishing a new rule do not apply to cases on habeas corpus review. The Supreme Court reserves the right to make a decision fully retroactive. So, Supreme Court decisions inevitably raise issues that then must be addressed in future judgments. So once they have this new rule, that means now this tells the court or gives all the courts, trial courts, and courts or all the courts below. It gives them direction. It tells them this is the new rule and this is how we're going to interpret it. So of course, as a judge, even on the low level, the trial level, you're now kind of bound by that. The Supreme Court decisions, like I said, raise issues that then must be addressed in future judgments. Court decisions often are not immediately or fully implemented by the police, prosecutors, or judges. So sometimes it is like a trickle down, as they say, a trickle down effect, where now um, we have to kind of figure out, have to give the law time to kind of, drop down to the streets where it's being interpreted, where now cops have to learn this new law, how it's applied. So let's see here. Two models of criminal procedure. Um, you have Herbert Packer, who proposed two ways of thinking about criminal procedure. Um, the criminal control model and the due process model. The Supreme Court in general seeks to find a balance between these two perspectives. So, of course, criminal control would be more about kind of controlling the system as opposed to just doing what's fair, which is the other model. But we won't go deep into that. We're not. I don't want to talk about a whole lot of philosophical things that the book says. I want you guys to kind of know history and the law. Why criminal procedure matters. The lesson of criminal justice is that people will support and respect the criminal justice system regardless of the outcome of a case, so long as they believe that the procedures are fair and objectively applied, and that decision makers are acting with integrity and treating people with respect. Um, I think we talked about those things that the criminal procedure, those aims that they kind of wanted to achieve, and that's one of the most important things. You can only A system only gets respect if it is at least on its face fair. You kind of can't stop the personal biases of the people that work in the criminal justice system, but if the system itself is fair, even if you don't get the outcome you want, um, you usually don't complain about it because you had your day in court. And I even find that as a defense attorney, a lot of times, I work my behind off. I work with my client. We go to trial. We put forth the best defense we can for my client. And sometimes, even after that best defense, we give it an all American try. And sometimes the jury may come back with a guilty verdict. But what I found in my I guess my time practicing law is that as long as they get that opportunity and they put forth the best case, you'll be surprised. Even when a trial is lost, a lot of times my clients are still satisfied because they got the opportunity to tell their story. And we'll talk more about that in roles of defense attorneys. But my number one job is to tell my client's story. Every client has a story. We got to tell it. So my job is to uh, try to, jump over the hurdles or evidentiary pitfalls to get my client's story told. Then, of course, my job is to also tell my client's story, kind of, give a summation in the most persuasive way possible to get a jury to see it our way and find my client not guilty. So my number one job is to tell the story. Just because I tell the story doesn't necessarily mean that a jury is going to believe it or going to believe that what my client's actions were right. So sometimes, even when I tell the best story, sometimes the story, even as it's told, as my client wants it to be told, just isn't good enough. But when we go through the whole process and they feel like everything's fair, they haven't been cheated, and nothing is biased, even when they don't get the outcome they want, they're still proud that they got their day in court. So, fair procedures also tend to result in more accurate results. So when we make sure the system is fair, things normally come out the right way. So when we put rules in place that stop law enforcement from being unfair, a lot of times the right thing happens. So if we don't allow law enforcement to beat up on uh, on suspects to get confessions, and we make them actually follow rules and actually go out here and investigate, we're more likely to get the right person. Of course, we've seen, the why they see us, drama, and you see how a person, if they're beat up, they're going to say anything, even if it's not truthful. And meanwhile, the real criminal is out here still raping and killing people, but you've arrested five people who didn't do it, and they essentially gave a confession based upon the fact that they were being tortured. So that was not an accurate outcome. So we want the right outcome. The one that's the one of the things the criminal procedure. The reason we have criminal procedural laws is we want the right thing to happen. We want the accurate thing to happen. So that is chapter two in summation. So I essentially hit on all the major points of chapter two. Of course, if you have any questions, please email me, and I'll see you guys later on. Be good.